based on the transcript, the judge here, Stacia Buchanan, did not abuse her discretion, and there could be a conclusion from the evidence in here. This docket 23845FH and 23842FH, People of the State of Michigan versus Rashawn Thomas II. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Brett Buxton on behalf of the people of the State of Michigan.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Thomas, who is standing to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
All right, thank you. And have you had enough time to talk with your attorney?
Yes.
I have this as a plea hearing. However, I do not have any paperwork on behalf of the people. Are we proceeding that way, or Mr. Goodrich, do you want to jump in?
Your Honor, the people have offered a plea offer. There was long conversations with both me and Attorney Goodrich. And the people ultimately offered a plea agreement to count 3 felonious assault and an added count 9 of home invasion second. The max for the felonious assault would be 4 years. The max for the home invasion second would be 15 years. Upon successful plea and sentence, count 1, home invasion of the first degree. Count 2, 4, 6, and 8, the felony firearm charges. Count 5, felonious assault. Count 7, possession of a firearm by a felon. And the habitual offender second status would be dismissed. 23-845-FH would also be dismissed in its entirety. And there would be an agreement for a fixed minimum sentence of 43 months to the Michigan Department of Corrections. There have been talks back and forth between me and Mr. Goodrich, and it sounds as though Mr. Thomas does not wish to accept that plea offer. If Mr. Thomas were to go to trial, I've had a chance to run the sentencing guidelines on this case. If he is found guilty of the charges as they are, I have the guidelines at 78 to 162 months, plus the additional 24 months that would run consecutive under the felony firearm charges. For the plea offer that I have given, there is a guideline range of 43 to 86 months.
Is that full, fair, accurate, and complete, Mr. Goodrich?
Yes, that is the offer that has been conveyed to Mr. Thomas. Mr. Thomas at this time would like to decline that offer, and in speaking with him, Your Honor, he would like to be able to represent himself in order to file some motions in this case and proceed while representing himself, Your Honor.
Sir, you would like to, first of all, the offer that was stated, that's full, fair, accurate, and complete?
Yes, ma'am.
Okay, that's different than the other ones I had written down prior, so. And you are not interested in that, is that correct? Did anyone force, threaten, or coerce you to make this decision?
No,
Did
ma'am.
anyone promise you anything that caused you to make this decision?
No, ma'am.
All right, and you no longer want Mr. Goodrich to represent you?
No, ma'am.
And why is that?
So I have some arguments I want to make.
What are, you have arguments you want to make?
Yes.
Okay, and did you get a law degree while you were in the lockup?
You said what?
Did you get a law degree while you were in lockup?
No, ma'am.
Okay, so tell me about those
That's by
motions.
counsel.
Sir, I know, but I know Mr. Goodrich a very, very long time. I don't know anything about the conversations you've had, but I have seen a lot of plea agreements, and I'm concerned, first of all, about what the motions are. Second, this is a plea agreement that's so good I might not even take it, because, I mean, you've been in a long time. How long has he been in?
I believe it's 31 months, Your Honor.
Okay, so 31 months minus the 43, you have about another year if you took the plea. And it wouldn't even be a year in MDOC because it'll be probably 7 or 8 months by the time we get the pre-sentence investigation done and all of that. under the, if we go to trial, and it looks to me like, based on the preliminary exam transcript, that there may very well be a likelihood of success. We'll talk about that in a moment, but the guidelines, what did you say, 78 to 162 months, that's what I've written down, is that right?
Correct, Your Honor, plus the additional 24 consecutive for the felony firearm.
So that's somewhere, my math isn't so good, but that's somewhere on the minimum of 8.5 to 15 years. If I were, I don't know anything about your case really. If you were found guilty, with the habitual, the home invasion first degree is punishable by approximately 30 years. On the minimum, it might be reasonable to give you 15 years plus the 2 years, which would be 17 years. Even if I look at the low end of the guidelines, that's 8.5 years plus 2 years, so that's what? 12 years or something, it's 10.5 years. Minus the 2 years you've done, it's still a lot of time. And even if you appealed, you'd be out. If you took the plea deal, you'd be out before the appeal was probably even read by the Court of Appeals. I'm not understanding unless you have a really good defense. So that leads me to what motions?
Quash the bond over, so bond over no physical circumstantial evidence,
Okay,
just off statements alone.
okay. Well, I'm sorry, but I have the transcript. It was put in here so over the 2 years that you've been in for various reasons, I suppose, but let me look. Have you read the transcript? I mean, you were there at the preliminary exam, right?
Yes.
And there's a couple of eyewitnesses, right? And one of them is, let me see if I can find her name. It appears someone who knows you pretty well, Ms. Mays. Do you know Elizabeth Mays?
Yes.
So her eyewitness testimony is evidence. And she says, under direct examination, and so you were able to see his face? Answer, yes. Did you recognize him? Answer, yes. How did you recognize him? I have a long-time friendship with his girlfriend and him for about 5 years. I've known him for a very long time. And it's more of like immediately when we caught eye contact, my mouth said before my mind could even like get everything around it, I just immediately said, Ray, why are you like, if it's because of Anna, I will leave her alone. And then he took off and left. Okay, so we are going to leave that and come back. Then it goes through how she recognized you. And what was his name? Ray Sean. We call him Ray though. Would you recognize him if you saw him today? Yeah. Is he present in the courtroom? Yes. Okay. Where is he located? He's off to the right in a blue button-up. Okay. Witness identified you, sir, not somebody else, you. And it goes on to say that you were in the apartment, and that goes to the elements of home invasion first degree. You were not invited. And then we have a second witness as well. So I sat in district court as a district court judge, and it's probable cause to believe a crime was committed. Probable cause that defendant committed the crime. Just on that one witness alone, I would have bound it over. And that tells me that there is a reasonable likelihood of conviction, and I will not quash the bind over. Mr. Goodrich can write me a brief that's so high, it lifts him 8 feet in the air. Based on the transcript, the judge here, Stacia Buchanan, did not abuse her discretion, and there could be a conclusion from the evidence in here that you are the person who caused these crimes. So quashing the bind over, you can do it yourself, you can do it through Mr. Goodrich or any other attorney I can appoint, and the answer is that it will be denied. just based on my reading of the preliminary exam transcript, which is what I would have to do. What's your next issue that he won't file? Or is that it?
Well, I don't care what allegations a person makes. I don't care what this person says. I didn't do it. There's no evidence or nothing that proves I did
She
anything.
is the evidence, sir. I don't care if you go to the Department of Corrections. If you want to go to the Department of Corrections, we're
I
gonna go
don't
to
want to
jury
take a
trial.
plea.
You don't have to take a plea. We can
All
get a
right, so
jury.
let's move forward from this.
Okay, so let me make this very clear to you. This is a final pretrial conference. The offer will go away today. We're gonna work toward trial, which means if you interrupt me, we'll start with contempt and I'll see you in 93 days.
I don't care.
93 days. You wanna have that attitude in this court? Mr. Goodrich, you're relieved. He can represent himself. And we're going to proceed to get a trial date. We're done. That trial date will be after the 93 days, which will give him time to prepare. This delay is on him, and we will proceed to a jury trial. You got your wish. Thank you. Next matter.